Good afternoon and welcome to our webinar, the American Rescue Plan Act of 2021, which provides updates for COBRA and dependent care. Thank you so much for joining us this afternoon. It was a very last minute webinar, so we are certainly glad that you took the time out of your day to join us. We are here, I'm Casey, the Director of Marketing and Communications at Medcom Benefit Solutions, and I am joined, of course, by the incomparable Michelle Barki, our Senior Legal Counsel, and so many other things here at Medcom Benefit Solutions. Just to let you guys know, as we have some new people who are joining, this presentation is being recorded. We will be able to provide you the slide deck and link to the recording after the presentation concludes today. So please just keep that in mind. If there is something that you miss while we are presenting, it is being recorded and we will be able to provide that recording to you along with the slide deck after the presentation. We also have a questions panel and we have, believe it or not, already have some questions coming in today. So we know that we're going to have a lot of questions. As you know, this is very new legislation, so some questions we are prepared to answer. Some questions we may need to do a little further digging, a little bit more research, but just know that we will provide those answers to you if and when the time comes. So just to let you know, feel free, as Michelle's going through the presentation, to put your questions into the questions panel and we will address everything at the end of the webinar. Just once again, before we get started, this webinar is being recorded and we will be providing the handouts and the recording link after the webinar concludes. So without further ado, Michelle, I'm going to go ahead and turn everything over to you.
Well, thank you, Casey, and welcome everyone to this afternoon's presentation. Are your heads spinning yet with all these law changes that we've had since COVID? And we've had some pretty fast things happening in the last couple of weeks. So hang on to your hats as we start going through the American Rescue Plan Act. It was actually signed into law on March the 11th, and we are now March the 16th, so only 5 days ago. We want to update also what they did with the Family First Coronavirus Response Act, what they did with the dependent care programs, and also the big one was saved for the end, the COBRA subsidies. So let's start with the Family First Coronavirus Response Act. This went into effect on April the 1st of 2020 and was supposed to be done with by December 31st of 2020. It was mandatory for every employer that was, for employers under 499 and employers of all sizes if they were public employees, meaning they were governmental. It was done under the Consolidated Appropriations Act and under the Consolidated Appropriations Act, there was a voluntary continuance until March 31st for employers that were mandated to do it before December the 31st. And with the American Rescue Plan Act, it is now voluntary up until September 30th of 2021, with a little addition that we are now allowed to include in the paid sick leave vaccinations. So that's the good news. We can give that to our employees with PTO. So just a reminder for those who want to know what it is that the Florida Family First Coronavirus Response Act initially said is that it covers employees who have worked at least 30 days and are unable to work even remotely due to a bona fide need to leave and take care of their children who are in school. And that was the expanded family medical leave part. And it also was mandatory for public employers, regardless of size. And as we mentioned earlier, those that were under 500 or 499 or under. And it did mandate that we pay a certain portion of their salary. Under the paid sick leave portion of it, we were able to pay up to 80 hours of paid sick leave. And it was mandated again for the same amount of employees, 499 or less, or public employers regardless of size. And employees were unable to work even remotely due to a quarantine order from the state or federal authorities, or they were unable to work even remotely due to COVID-19 symptoms for which they were seeking a diagnosis. And again, now we can also give them paid sick leave up to, for the, to go get the vaccination. And then you get that recovered by your payroll taxes. There's taxes that you get back in order to cover the cost of paying the salaries. Now we want to get into the Consolidated Appropriations Act. It went into effect on December 31st, 2020, and it did allow the voluntary continuation of the Family First Coronavirus Response Act. The American Rescue Plan allows employees that had to mandatory comply to voluntary extent, that's the same thing. Next slide, Casey. Okay. The American Rescue Plan also allowed DCAP benefits to increase retroactively to January 1st, 2021 from $5,000 to $10,500. This is optional for the employer. So in other words, an employee can now elect to go back and take $10,500 in the DCAP. However, there's a few things to be aware of. Number one is the non-discrimination issue. We already have problems with DCAP and non-discrimination and passing that test. And it could be the highly compensates that are going to be able to do that $10,500. So just be aware of that before you rush out and say this is what you're going to allow them to do. Another part of this, and I think this is the reason that the government said this, is that under all the notices that we have got 2020, 15, and before under 2020, 29, the government did allow us to extend the grace periods for the DCAPs. And when you have the grace period, it is usually typically no more than 3.5 months. And now we've been able to do it up to the end of the year, and we can do it now from 2020 to 2021 and 2021 into 2022. So basically what happens though is that when you look at DCAP, at the end of the year, it's what you spent that you get the tax benefit on. And typically you can spend $5,000. And if you spend more than $5,000 because you've extended the grace period, you've allowed monies to be carried over from the previous year into the grace period, and then the employee elects $5,000, and let's say they spend $6,000. That extra $1,000 is typically taxable, and the employer does that by filling out a form at the end of the year. They tell the government that they spent $6,000 on childcare. 5,000 of it is forgiven, and the 1,000 they have to go back and pay taxes. So with this $10,500, it's actually helping us with this grace period extension, so that if somebody carries over 3,000 or 4,000, that $10,500 should help with the taxes at the end of the year for any amounts that they carried over. Again, this is optional for the employer. You do not have to allow this $10,500 to be used. The COBRA challenges that we are experiencing right now are absolutely humongous. We have the outbreak period. We have the DOL notice 2021-01 that was coming out on February 21st. And we have the American Rescue Plan Act of 2021. So let's go ahead and just refresh ourselves with what the outbreak period said. It said that the departments, which meant the Department of Labor, the Department of the Treasury, the IRS, and the Department of Health and Human Services were all in agreement that during COVID, individuals were having a hard time either paying certain bills, getting claims paid. So basically what they did back last year is they established an outbreak period from March the 1st, 2020, and it was supposed to end 60 days past the national emergency. And this was for all ERISA plans, basically. It was not for public health services plans, the government plans, but they did strongly encourage the plans under the PHSA to also comply. The Department of Health and Human Services asked them to. But what happened is nobody thought the national emergency was going to go this long, and it did. It continues, and it's still continuing. The only way the national emergency ends is by a declaration by the president, and we haven't had it yet. So here's the issue that we were running into with the outbreak period, is that the Department of Labor, the IRS, and the Department of Health and Human Services, they're not elected officials. They can't just pass laws. What they can do is make rules, but only rules under their authority. And way back when, the Congress gave them the right to make rules for up to a year in the case of a national emergency. But nobody expected this national emergency to last as long as it has. And oh, by the way, we talked about March 1st of 2020 when it went into effect. So it was doomed to terminate on February 28th. So basically that was all the background of this. Under ERISA, they had the 1 year as they did under the IRS code. Now this was kind of missed for the longest time. And then we see more and more chatter about this. I know I worked with a couple of attorneys and we all agreed back towards the end of January that this must come to an end. But the DOL did not issue any guidance, nor did the IRS, and they didn't even acknowledge this until February 26th. If you look at your calendar, February 26th was a Friday, and they would lose a jurisdiction on the 28th. So basically what the DOL and the IRS did in order to continue the outbreak period is they say, okay, we have a year's jurisdiction. So if we have a year's jurisdiction, it's no longer going to be from March the 1st to 60 days past the end of the national emergency. We are going to do this based on the individual and when his COBRA should be elected and when he needs to get noticed, and then go from a year from that point. This also affects special enrollment rights for children, for newborns, and dates to submit claims and dates to request appeals. So now we're going to a year from the date for the individual, and that makes it a whole lot tougher. So they also said, and this is the DOL, said, where plan administrators or other fiduciaries know or should reasonably know that at the end of a relief period for an individual, action is exposing that individual to potentially lose protections, you have a duty under the plan to notify them. So all of a sudden, we have to notify the individuals of this outbreak, of this new outbreak period and under the changes. Now, I will tell you, when the original outbreak period started from March the 1st of 2020 through 60 days past the end of the national emergency, everyone was waiting on guidance from the DOL, like, what do we do about notification? Where's the model notice? The DOL issued a brand new model notice. Everybody ran to it thinking that it would include the outbreak period. And all it talked about was certain issues under Medicare and COBRA. So we were all very, very disappointed. We kind of made our own documents. We sent it out to individuals. But here, now the DOL is for the first time coming out and saying you have a fiduciary obligation to do so. So plan administrators, you need to think about sending these notices out, and you need to be talking to your COBRA administrators regarding this as well. And then they also said that the information, should be kind of accurate, and we need to make sure that, all the notices are in place. And then they also said something kind of unique, and they said ERISA group health plans should consider ways to ensure participants and beneficiaries who are losing coverage under their plan are made aware of other coverage options. Well, that makes sense now, because also we know that the marketplace reopened for open enrollment. Typically it closes in December and you're only allowed to go to the marketplace if you have a special enrollment right. But it was reopened from February the 15th to May the 15th. So now these ERISA group plans, we should also let them know that they also have the option of going to the marketplace and So that's another thing that you should put in your notice. And then they said plan fiduciary should make reasonable accommodations to prevent the loss of coverage or undue delay. So that means we need to make sure that we get these things out as soon as possible, because we don't want to have anybody lose benefits because failure to comply with pre-established timeframes. And potentially this opens up possibilities for additional extensions or deadlines where facts and circumstances would argue for additional flexibility. So it almost looks like the DOL is trying to say, be as lenient as you can with these timeframes and do what you can to make sure that people are covered. We know the carriers are absolutely going to adore us for this. So what are the notification challenges? So basically what it's coming down to is the outbreak period was from March the 1st of 2020 through April the 31st to February, to 60 days past the national emergency, or now it's up to 1 year from the date that they would be eligible to elect. And then we also have to consider that if the national emergency ends before then, what is the date that it would actually terminate? It's the earliest of the 60 days past the end of the national emergency, or individually 1 year. So now it's not just a question of we have one or two individuals in any given employer. We're talking about a year's worth of employees who have potentially gone off work that we have to notify. So that's going to be really, really difficult. We need to know the IRS has to do it as in short a time frame as you can possibly do, but they provided us no advance notice. They lost jurisdiction on February 28th. They notified us Friday afternoon on February 26th. It did not help. Now, there's going to be a lot of additional costs to do this mailing. And so expect your third-party administrators who are your COBRA administrators to have a special fee for this. More likely than not, that will be part of the TPA contract. The plan fiduciary, which is your plan sponsor of your plan, the employer who administrates that plan, is the absolute fiduciary, and she has to make sure that it happens. So again, contact your COBRA administrator and see what they're doing and how they're getting these notices out and how they're trying to do them. Some of the other issues that you can run into with this is that the Department of Labor wants you to be able to tell the individual when to go and actually, when their termination date actually is, so that if they were supposed to have elect the COBRA by February the 1st of April the 1st of 2020, they would have till March the 31st of 2021. They want us to make sure we give them the exact timeframes, the exact deadlines, but the COBRA administration systems aren't geared for that. We don't have that. We can put in an extra date in there. So we have to get a little creative and figure out how best to contact the individuals, how best to provide them the additional information, but it's not going to be as easy as just pushing a button as the government may have thought. And don't forget, we've got a lot of COBRA lawyers out there, especially in Florida. We have one very well-known COBRA attorney, and they're going to be all over this. They're going to be reveling in these changes and just rubbing their hands in glee that somebody might get missed. And but again, we've got to make sure that this gets done. So always talk to your plan, to your COBRA administrator and see what they're doing. Now, COBRA and subsidies. Employers are going to be able to cover 102% of the COBRA costs from April the 1st, 2021 through September the 30th of 2021 if certain conditions are met. They are going to claim this reimbursement through their payroll taxes. I think it's the Medicare taxes they're going to be able to reclaim this amount through. But it's only for employees who were involuntarily terminated due to COVID and not those who quit their job. And it might not even be just because of COVID. Anybody who was involuntarily terminated or even had a reduction of hours, it's going to be that's who's going to be eligible to get these subsidies. And again, the subsidies will go from April the 1st through September the 30th. Qualified employees do not have premiums or have continuous coverage. This is going to be considered a special open enrollment period for those employees who lost their job involuntarily or who had the reduction in hours. So again, you're talking April 1st to September the 30th. They might not have had or elected coverage, let's say from November to April. That's fine. This is a special period that they can enroll. Now, if their coverage was due to terminate prior to the end of September 30th of 2021, i.e. they would have met their 36-month, the special for 36 months or 18 months or whatever it was, they're only entitled to the subsidies for which months they would have been eligible had everything remained the same and nothing would have changed. And the other thing the government said is that the employers could allow them to reduce their coverage to a lower cost plan. So that potentially when they came off of September 30th, they would have a lower cost plan and reduce premiums. I also think it's because the government doesn't want to pay as much, so they're trying to encourage us to allow them to go to a lower cost plan. Now, don't forget, this is a special ability to go to the lower cost plan if the employer desires. It's not like somebody at open enrollment being able to change plans, which they can still do under regular COBRA. This is a special one just for these individuals who have lost their job, reduction in hours, and it's going to allow these employees to reduce their cost of the plan if the employer lets them do so. So the special enrollment period, they can enroll within 60 days from the date which they receive the COBRA subsidy letter. Yes, we have to let them know that they have 60 days to enroll in COBRA in this special subsidy when they get this special subsidy letter. They do not have to be enrolled, as we talked about in COBRA presently. It's a special open enrollment period for April the 1st to September the 30th. And you know how our carriers are going to love that. These people don't have coverage these dates, they have this date. And they have 90 days, we believe, from the date of the receipt of the notice to enroll in a lower cost plan if the employer so allows. Now, subsidy challenges, boy, oh boy, there's going to be plenty of subsidy challenges. As you know, Medcom Benefit Solutions is also a COBRA administrator, and boy, have we started to identify some of these issues. The number one is identifying those that are entitled to a subsidy will be difficult. You all know that when you punch in for your the employers for qualifying events, it's like, do you have a termination? Do you have a reduction in hours? Do you have has a dependent aged out or whatever? But we typically don't ask, or it's not provided. Did you quit your job voluntarily or did you involuntarily get fired? So we don't have that information necessarily in the system. So employers are going to have to go back and they're going to have to provide the COBRA administrators with those that are entitled to the subsidies and those that are not. So that's one of the big problems that is out there. It begins April the 1st, so we must work quickly. Another issue is typically the employer now is going to get that 102%. They can claim the full cost of the COBRA premium. They'll be getting that 102% cost reduced from their payroll taxes, but that 2% fee still has to be paid to the TPA in order to do this. So we're going to have to work on all sorts of challenges on how that gets transmitted both back and forth. Employers, as we mentioned before, especially with the outbreak period, there's going to be an extra cost for doing these COBRA letters as well for the subsidies. And so they have to be aware of that as well, that this is going to be a collaboration effort between all of us to get this done. but it's going to be done at an extra cost, most likely, for most TPAs, I would imagine. And again, COBRA lawyers are going to be out there to celebrate these changes. And they're going to be, out there in groves, I imagine, especially in Florida. Now, one of the things that Medcom has been asked is, can I have my subsidy, from the brokers and from employers? When are you going to have the subsidy letters ready? When are we going to be able to see them? Can you get them out, now? We don't have a lot of time. And I agree with you. But one thing is, the government, even though they expect us to work quickly, they never work quickly. I mean, they come up with these things like with the outbreak period on Friday afternoon and expect everything to be done by Monday morning. It doesn't work that way, as we all know. The government is working slowly, and they have until April the 10th to get us the model notice. So it's going to be a conversation as whether we want to wait for model notices or whether we just want to forge ahead and go ahead and do what we think is best. So that's a discussion also for your brokers and the TPAs to discuss which ways we go. Do we wait or do we go ahead and forge ahead? So there's lots of things going on. The outbreak period and the subsidies in COBRA are huge. And we wanted to get this present to you quickly. We may not have all the answers, but let's go ahead and start seeing what we got and seeing if we can help with some of the questions.
Absolutely. Thank you, Michelle. We do have some questions that have already come in, while some others are typing in your questions. Just want to do a quick reminder that Medcom does offer additional solutions for your team. As Michelle mentioned, we have our COBRA administration. We also administer CDHP, consumer-driven health plans. We provide ACA employer reporting and penalty appeal support. We offer HIPAA privacy and security solutions, as well as a plethora of options under our health and welfare compliance and actuarial solutions. So Michelle, just to let you know that a lot of the questions that we've received today have multiple parts.
Okay.
I will do my best to address them all and make sure that we get everyone the answers that they are looking for. So, will the American Rescue Plan Act credit apply to employers that benefited from the PPP? Are the qualifying events of involuntary termination and reduction in hours exclusively if due to COVID, layoffs, furloughs, and other organizations due to economic impact of COVID?
Those are two very good questions. What was the first one again, Casey?
Will the ARPA credit apply to employers that benefited from the PPP loans?
No, it's two separate credits, so you can go ahead and get the credits for the subsidies as well. And the second part of the question is, it looks like it applies to anybody who would be entitled to COBRA between April the 1st and September the 30th, who were involuntarily terminated or who had a reduction in hours. And probably the reason for that as well is that it was a tough employment market as well. So we believe it's covering everybody who was eligible for benefits during that period of time, who were involuntarily terminated or who had an involuntary reduction in hours.
So is there a particular form to use to claim the credit?
That we do not know at this time. That's something for your payroll companies. Typically, they usually have some documentation and everything in there. I do not know about that, but we will certainly check to see if there is a form.
Okay. How will the new election period rule under ARPA work with the quote unquote pause on COBRA deadlines announced back on February 26th, the individual QED rule for the 12-month maximum period?
Okay, so again, that outbreak period pause is one thing. And you do not have to elect COBRA during that pause that we have that toll. So we're kind of looking at it as two separate things. As long as they're eligible for COBRA between April the 1st and September the 30th, any period of time in that time frame, that is a separate open enrollment right. That does not affect whether or not they go back and they elect COBRA during the outbreak period for any preceding months.
Okay. Also have.
And just to clarify that, Casey, also, that they have 60 days to elect in this special enrollment between April the 1st and September the 30th from the date that they received the COBRA notice to this effect.
Okay. Another multiple section, couple of questions here back to back. First question, if the plan that was in place at the time of the initial COBRA eligibility has since been replaced, does the assistant eligible individual have the right to elect the replacement plan even if the premium is higher? What if a group plan was replaced with an employer subsidized ICHRA?
Yeah, I think we're talking when we compartmentalize it, two separate things. So if the employee's plan has changed and this is what the new premiums are, or they went through an open enrollment and they changed it during an open enrollment separate from everything else, then what they're paying for their premiums is what's going to be covered at 102%. Now we get into the actual subsidies, the period between April the 1st and September the 30th. If they want to reduce the cost of the plan for the subsidy and then potentially moving forward, and if the employer so allows, then that's where that changes. But we've got to compartmentalize between, the enrollment rights under, a plan change and where they are at the plan now prior to this and where they're going to be with the subsidies if the employer allows them to reduce the plan.
If a reduction in hours was voluntary and the now part-time individual is still employed but not benefits eligible, does ARPA allow for a subsidy?
It does not, because it was a voluntary reduction in hours.
Okay. Does a voluntary layoff have to be due to the pandemic, or can it be for just cause?
Now, this is, you said a voluntary layoff. If it's voluntary, they're not entitled. If it was a mandated layoff, then they will be entitled to this subsidy.
How does the dependent care program increase work for a non-calendar year plan? An example here, a group with a plan year 10/1/2020 through 9/30/2021.
Repeat that, please.
Sure. How does the DCAP increase work for non-calendar year plan year? And their example was October 1st from 2020 through September 30th of 2021.
Yeah, you can extend the grace period between for plan years that end in 2020 into 2021 and for 2021 into 2022.
I got it. Thank you. Is the DCAP increase retro to January 1st, 2021? Can a participant submit receipts for reimbursements on expenses incurred retroactively?
I believe that this does go retroactively, but we will check it to make sure. But I believe that the 10,500, which is just for the 2021 year, is retroactive.
Okay. We were talking about time off given for vaccinations for employees. How much time off do you know?
It did not specify. It just said vaccinations were able to be continued in the hours off. So I think you would have to justify why you had so many hours off to get the vaccine. I think it's going to be down, a lot of it will be location too. I mean, some locations are much more speedy than others. Some are still waiting a while in line to get the vaccination. They have not provided any guidance on that yet. And I don't know whether or not they will with everything else that's going on.
Okay. If someone has a dependent care plan that runs on a plan year, and this may be similar to the question before, I'm sorry I haven't gotten through it. If they have a dependent care plan that runs on a plan year and is renewed on 8/1/2020, can they allow their employees to increase their current elections on January 1st, 2021?
Yes, I believe that they can, but we will check that out. But yes, I believe that they can.
Okay.
And again, this is up to the employer.
Okay. Do we know, this is just a kind of a question, as Medcom is a COBRA administrator, do we know how we're going to be sending out notices for current companies and any kind of news that we can provide for clients?
Yes, Missy Brown, who runs our COBRA department, and myself have been talking about this ad nauseum to make sure that we get it out. For the outbreak period where we have to go back and send out a lot of COBRA notices, we are going to have two options. One option to our employers are going to be that we will prepare the work and then send them out to the employer in a data sheet, and the employer can then actually do the mail. And I believe that that will be at no cost or just a minimum cost. And then for the actual letters, if we are doing all the work and mailing out the letters, I think we're going to ask for a fee. I think it's going to be in the range of $3 to $5 for the mailing of the letters. So we're going to provide two options. We are currently working on the letters. We're currently working with our platform provider to see what they can provide and when they are providing the letters. We have already written our own. The biggest issue is drawing the dates in and things like that. The other issue I failed to mention, and I'm sure a lot of other TPAs are going to have the same issue, is providing a toll-free number will probably not be an option. Systems just won't handle 70,000 people calling in, or even a percentage of that. So we'll probably provide an email address, but we're still working out some of those details.
How do these regulations apply for non-ERISA groups?
Okay, that's a really good, very, very good question. The non-ERISA groups are not subject to the outbreak period unless the governmental plans, unless they voluntarily complied. Subsidies, doesn't matter. The subsidies, believe it or not, are going to apply to ERISA groups, to the PHSA, which is your government plans. And then, you know, those pesky little church plans that might be out there that aren't subject to ERISA. Well, the government said if you have any state continuation, basically, we believe state continuation is also going to be covered. So the church plans, if you have a state continuation that allows church plans, and if you have an employer that's under 20 and has a state continuation, the subsidies will apply to that as well. To the limit of the state continuation. So we have to look at that as well. So outbreak period, basically it's for ERISA plans and PHSA for the public companies if they so chose. So that's another issue we have to address with the governmental agencies, whether or not they chose to do this. Subsidies, everyone across the board. And oh, by the way, if you have an individual coverage HRA, yes, that is also entitled to the subsidies. If you have a small employer HRA, not subject to the coverage because small employer HRAs, COBRA was excluded for them. So we have to look at that as well. So lots of variation here between the outbreak and a lot of variation over on the other side with the subsidies. So lots of work to do all the way around. And, we're working very closely with our broker partners, and they've been absolutely great and relaying the news to our employers and getting all these questions answered today.
Excellent. Thank you, Michelle. As far as the notices go, can they be sent electronically or saved on a company intranet? Are there any guidelines there?
There is absolutely no guidelines there as far as these letters are concerned. But if you go back to the original COBRA letters, they're typically sent out by mail because we have to make sure that all qualified beneficiaries in the household are included. And we don't know on the intranet, the government has never really considered that an official notice. So we haven't got any guidance. So we believe that it should be by mail to make sure all qualified beneficiaries are notified.
That makes sense. I think we kind of touched on this earlier when we were talking about Medcom, but who is creating the notices regarding the new guidance issued on February 26th?
Medcom benefits, we've been working with those notices ourselves.
So basically be the plan administrators, right?
Yeah, I mean, we're working on them, Casey. We writing what we think should be in the notices, and then working with the plan administrators to see whether or not they want any changes. But basically, it's going to be a standard letter. We don't have a lot of time to customize for each individual client. So it's going to be basically one letter. Missy Brown, who is a director of COBRA, and myself have been working constantly on it. The DOL has not issued any guidance, like they did not issue any guidance for the first. The only thing they told us is what I mentioned in this presentation, that they expected under the fiduciary obligations of the plan administrators that notifications would be sent.
Thank you for that, Michelle. Do we have to notify every member that was terminated since the start of the national emergency period?
Basically, anyone who is in that outbreak period who would be entitled to benefits after March the 1st, COBRA, after March the 1st, would need to be notified. If their coverage period ended by March the 1st of 2021, for an example, February 28th, they would have had to notify us. Then no, they're not going to be notified. So it all depends on where they are in the outbreak period and where we have. But again, you only have 1 year or the date of the 60 days past the national emergency, whichever is earlier. So for an example, if somebody was supposed to elect COBRA by March the 1st of 2020, their deadline was February 28th of 2021 for their year, and they would not be notified.
For the dependent care change, can we pick any amount from $5,000 to $10,500 if we don't want to offer the full $10,500?
Yes, you can.
Excellent. What should a person or a company do if a plan sponsor changed COBRA administrators and neither the current or former administrators are facilitating the notifications?
Oh, this is a really tough question, and it is one of those areas that's really, really difficult. I will tell you, for an example, if Medcom, and I can already tell you what Medcom has discussed internally within our organization. If you are a new employer with Medcom, and we don't have the information to send out the letters, we don't. From all your past people, we would provide you with our sample letter so that if you got the information from your previous carrier, then you could send out the letters directly. So there's a lot of things out there that are still kind of trying to be worked on, but it's going to take cooperation from everyone. We're going to try to not leave our employers hanging. We'll do everything we can. But at the end of the day, if we don't have the information, we can't send out the notice. So that's just the way it is for us.
Thank you, Michelle. So it stated that fiduciaries must advise the qualified beneficiaries. However, it also stated that a COBRA administrator will send the notice. Which one is compliant?
Okay. Well, your COBRA administrator is not a fiduciary. The fiduciary is the plan sponsor. They're the ones that are on the hook with the DOL to send it out or to make sure that it's sent out. Your COBRA administrators typically have contracts with you, and it explains what their role and function is. And typically in those contracts, it says they are not the fiduciary. Now, again, Medcom is working very closely with our broker partners and with our employers, trying to do everything we can to assist our employer partners with this. But at the end of the day, just as it is with everything, the actual fiduciary of the plan is the plan sponsor, is the employer.
Thank you. Does this cover employees who were terminated for cause but not for COVID?
if they were terminated for, okay, this is what it actually said. If they were terminated, involuntarily terminated, and then it talked about a gross misconduct exception. So I would have to look more carefully whether it was for cause, whether that would count. But they did mention gross misconduct, which, as you know, anyone who has attended some of our presentations, is a very, very high standard. We will take a look at whether or not a regular cause, but I think the government wants to make sure people are covered. So they've got those two challenging issues that they want to make sure that people are covered, and this is what they're going to do. But I will take a look at that cause before giving a final decision on that. But they did mention gross misconduct other than gross misconduct. So we know gross misconduct would not apply. Okay.
In what situations does the outbreak period, what situations does the outbreak period apply? I think there's a follow-up to this for increased dependent limits and carryover.
Okay, the outbreak period applies to claims, so that if you have a claim submission that needs to go in, that period of time in the outbreak period is also carved out. So if an employer, for an example, has an FSA with a run-out period, and that gives people the time to get the claim in, that run-out period is continued during this outbreak period. I will tell you that we haven't had too many problems with this. Basically cards are used for the most part, the credit card, debit cards are used with FSA. But if somebody is submitting a manual claim, they've been getting the monies in pretty quickly because of the fact it's their money. But that run-out period can be affected. Special enrollment, right? So you have a newborn baby and typically have 30 days to put the baby on the plan. That's part of the outbreak period. If you have a medical claim, plan, and the claim is supposed to be submitted within 60 days, you've got whatever the plan says, you've got that period is extended. If you have an appeal process, that period is extended. If you have an external appeal, the period of time to request that external opinion has been extended. So there's quite a few different things out there that will extend the time frame. Again, for our runouts, we haven't seen that particularly being an issue, but it is part of the runout in case.
Thank you. If someone was terminated in April of 2020 and did not elect, can they elect now?
Can they elect their coverage now? Yes, because they terminated in April of 2020. They would typically, have 60 days to elect from the date of the notice. The outbreak period is from March the 1st of 2020 through 60 days past the national emergency, or 1 year. So they would have some additional time still to do so.
And so since they can, would the subsidy only go from 4/1 of 2021 to September 1st of whenever?
No, because once they elect, they would have the 18 months of COBRA, for an example. So as long as they were in their 18-month of election, then they would be able to get the benefit for that 18 months. It doesn't depend on when you elected under the outbreak period. This is a special enrollment, right? They can still elect. So because they elected this special enrollment, and as long as it's part of that 18 months or 29 months or 36 months, they can get the subsidy through September the 30th.
If a group's open enrollment falls between April and September, would a COBRA qualified participant then be able to increase their plan election and still get a full premium subsidy?
Repeat that, Casey.
Sure. If a group's open enrollment falls between April through September, would a COBRA qualified participant then be able to increase their plan election and still get a full premium subsidy?
I believe the answer to that would be yes, because we're talking about the plan year ending, and they would normally have that right to change their election. So it's not a special enrollment right. It's it's a right that they would normally have. So I believe that we would have to say yes, but I will check that out too.
So how far back do we look to determine who is eligible for the subsidy based on involuntary term or a reduction in hours?
Anybody who would have been eligible to receive COBRA during that period of time. So if you're looking at 18 months, could go back 18 months, as long as they were, elected during the appropriate time frame. So it's going to be a little bit of a challenge to figure it all out. But yes, as long as they were eligible for COBRA during that September, any part of April to September is what we're looking at basically.
Just to clarify, is it the carrier or the employer that pays the subsidy and takes the payroll credit for a fully insured plan?
Great question. It's going to be the employer. The employer is going to be the one that gets the credit. Initially, it looked like it was going to get really confusing between fully insured and self-funded, but that got changed, it looks like, when it went back to the Senate and then back to the House. So it looks like the employer now.
Okay, just a kind of a brief announcement. Yes, we will be sending out the slide deck and this recording, including this Q&A session after that today. So the questions that have come in about that, please be assured you will have a copy of this presentation. Does the participant have to pay retroactive premiums to enroll under the new special period? And how about adverse selection?
You know, the government is great with adverse selection, aren't they? No, this is a special enrollment between April the 1st and September the 30th, as long as they're COBRA eligible, and they do not have to pay the back premiums. And yes, there's going to be adverse selection because, this is a free benefit. Now, I will tell you, one of the things that I didn't tell you before is that the qualified beneficiaries are not eligible if they have other coverage or offer of another coverage. So for an example, if they work for another employer and they had employer coverage there or offer of coverage there, they would not be entitled. And the government made that very clear too. So we have to make the employees aware of that as well.
So how far back do we go with it? I'm sorry, we've already answered that question. Does the COBRA subsidy include the furloughed workers?
Yes, if they're furloughed, it's an involuntary layoff, yes. For the period of time that they were, if they're still furloughed, yes.
I gotcha. Is the subsidy required for state continuation?
Yes.
Okay. I think we briefly discussed this at the beginning of the Q&A, but is there a clarification on who is responsible for delivering the notifications, whether it's the COBRA admin or the employer?
The COBRA, the plan sponsor is the one that is responsible. They are the plan administrator. They're the ones that are absolutely responsible. COBRA contract carriers are done by, the COBRA administrator is a contract. So you have to work with your COBRA administrator and work it out that way, who's doing what. Again, with the subsidies in particular, the COBRA administrators probably don't have all the information. They don't know who was voluntarily probably versus involuntarily terminated. So we're gonna all have to work together to get that information and then work with your carrier as to who's doing what. If your carrier is doing it, I would imagine there's going to be some extra cost to it.
If a COBRA participant has already paid their premiums for April, how will they get a refund for the COBRA payment?
The employer would have to reimburse them. They would get the money through the payroll taxes, and you have to reimburse them within 60 days.
Got it. Would dropping COBRA at the end of the subsidy qualify as a special enrollment for someone to then enroll in the marketplace? Normally, voluntarily dropping COBRA is not an SEP.
The government hasn't said how that is going to work yet, so we'll have to wait for further guidance come closer to September. And you never know, come closer to September, they may decide to continue the subsidies again like they did under back in 2009. We just don't know what's going to happen. So that's a question that we will look at, and look to see what the government says as far as special enrollment periods into the marketplace.
Do COBRA extensions apply to non-medical plans? Also, for those that had non-medical COBRA termination during the outbreak period, should they be offered the option to re-enroll?
We're not 100% clear on whether vision plans and dental plans are covered under this. We know the major medical is. We know FSAs are not covered for the subsidies. So that's the first part of that question. And again, we're still waiting for some more clarification. Again, this came down on March the 11th and we're March 16th. So there's still a lot of unknown answers out there. And what was the second part of the question, Casey?
For those that had a non-medical COBRA termination during the outbreak period, should they be offered the option to re-enroll?
I'm trying to think of, if they had it during the outbreak period and it was a non-medical, if it was I'm trying to think of how that would apply. Let me take a look at that one afterwards and try to get some scenarios on that.
Will the tax credit received on the subsidies include the 2% that client has to pay to COBRA administrator?
Yes, it will. They indicated that it would, and they just said the cost of COBRA, and the cost of COBRA includes that 2%.
What if the COBRA qualifying event is the end of FMLA?
That's not an involuntary termination as far as, we'd have to look at that, determining more. I would need to look at that because of everything else. So let's take a look at that, but it's not really an involuntary termination. The person didn't come back to work. So let's take a look at that. We don't have any information from the government if they don't come back to work and it's COVID related. I don't have any information on that at this point.
Okay, I have flagged a couple of these questions that are about FMLA and returning from work so that we can follow up with that afterwards. We've got a long list of questions here. I'm trying to get through them as quickly as possible. If someone was involuntarily terminated in July of 2020 and they elected COBRA and are still on COBRA today, are they eligible for the subsidy? Everybody's just trying to understand this, but I think there's a bit of a confusion here.
Yes, they would be eligible for the subsidy if they were involuntarily terminated, paid their premiums. They can now get the subsidy from April the 1st to September the 30th. They are not penalized for paying their premiums, in other words.
I gotcha.
And that's where that 60 days to return premiums comes into too. So somebody, paid April because they've been paying all along, then we have 60 days to return that premium.
Okay. Clarification on how it works for individuals who are eligible for COBRA but stopped for whatever reason, and assuming they would still be eligible based on the dates, what would that mean? For example, would they have to pay premiums missed up to April 1st, 2021? Are there any other repercussions?
No, if they paid their premiums and then they missed, the government is clear if they're entitled to that subsidy. April the 1st to September the 30th, it is a whole different COBRA election. So we don't look at it as a regular COBRA election where you have, you have so much time to elect and you might be in the outbreak period and it might have been told. This is a special enrollment right for COBRA just between April the 1st and September the 30th, regardless of what you did with your regular COBRA, if you're entitled.
So the COBRA subsidy only applies to those termed from 4/1/2021 to 9/30/2021, not someone still in the election period.
No, it's not for those termed between 4/1 and September 30th. It's for those who are eligible for COBRA during that period of time. So if they're in their 18-month COBRA and the April the 1st and September the 30th fall within that 18 months, that's then they would be eligible for this subsidy if they meet the qualifications, involuntarily terminated or had an involuntary reduction of hours.
Will COBRA members be able to have a gap of coverage in COBRA?
Yes, because you might not have previously elected COBRA not paid, and then you had this special enrollment right between April the 1st and September the 30th. So yes, there might be a period that you're not covered under COBRA, but now you can get COBRA under this subsidy.
Got it. Are employees who are terminated for not following procedures, okay, this kind of goes back to the question about reasonable cause, which we talked about earlier.
Yeah, we'll check that out. I know that the government made a specific notion of gross negligence or gross misconduct, but I don't know whether or not they would go with that because they were, performance issues.
Right. If an employee was unable to return from a medical LOA in October, okay, this one was also about FMLA, which we're going to get some more clarification on as well. Let's see, I'm sorry, I'm going through all of these questions here. Let's see, I heard that some of the group furloughs group furloughs as a qualifying event. Group furlough is not a qualifying event, correct?
Okay, if you've terminated, people apply furloughs all the time. If they're still on your payroll and they're not a qualifying event and you didn't offer them COBRA, then no, they wouldn't be entitled to COBRA. But if you're using the term furlough, you laid them off and you terminated them and it's a qualifying event, they're entitled to COBRA, then it would be a subsidy eligible COBRA between April the 1st and September the 30th.
What happens if a former employee elects COBRA and they pay it, but it turns out they have other coverage? Do they get a refund?
They should. I know that the government is going to be very strict with those who take a subsidy and have other coverage or an offer of other coverage. I don't know whether or not they, that because the government is going to be going after those guys. That's all, the answer to that is it all depends on what your plan document says and when they were notified and why they paid the COBRA. And that goes into a whole different issue than just outbreak periods of subsidies. So that we would have to look, yeah.
I'm sorry, I didn't mean to interrupt you there, Michelle.
Yeah, so I was just saying that's a whole different discussion as to why somebody would have COBRA and other coverage and whether or not, when they notified and everything else. So that's a different discussion, not so much this one. And I'd have to look to see what back case law said on that.
Can you confirm if subsidies are optional or required?
Subsidies are required.
And so do large group church plans that we talked about earlier, do they need to provide these subsidies?
Yes, everyone has to provide these subsidies. Church plans are typically, well, let me go back with church plans. Large group church plan, if it's may not be required to do that because they are not under ERISA or they're not under the PHSA Act. But if they're in a state that has state continuation that says church plans, then yes, they would have to do it too. So you'd have to look at your state continuation.
We talked about the process that, you, Michelle, and Missy, our director of COBRA, have been talking about. What's the process going to be for groups for which Medcom is the FSA DCAP administrator?
For the outbreak period, the process is the same. FSAs are not entitled to subsidies.
Right. Okay. This is a question about an HRA notification. Does it have to be separate noticed in the COBRA benefit?
I will have to look specifically at HRAs.
Okay. If the employer has had employees sign a consent for electronic distribution form, then electronic should be okay, but that goes back to making sure all of the qualified beneficiaries get notice.
Yes.
Okay. Do the subsidies cover the dependents of the involuntary termed employee?
Yes.
Okay, I believe this is kind of rounding out the questions. We're getting a lot of kind of those repeat questions. What we're going to do is take a look at all of the questions that came in today through this period, anything that we have flagged, things that we need to notify as far as Medcom clients go, and definitely put this information out for you. What we will do immediately as soon as this presentation is processed is get you the slide deck copy and a link for the recording. After that, we will go through the question list and make sure we come up with a little bit of a Q&A for all of the questions that were mentioned that we weren't able to provide information on immediately, and share that information with the attendee list as well. We want to thank you so much for joining us today, for being here, for being patient, and for understanding that we are all learning all of this all together. We will be here to provide you with updates as soon as we have them. And like I said, if you ever have any questions or follow-up, you can always reach out to us. You can reach out to our sales team, but you can also reach out to Michelle Barki or myself and with any questions, and we will try our best to answer them at the time. Michelle, thank you so much for sharing your knowledge today. Thank you to everyone else for joining. Have a great afternoon.